Good morning, good afternoon, good evening, everyone, wherever you are. So now we have the guest lecture by Professor Pazartzis. I'm very honored to introduce her, and she is no stranger to CIL eAcademy. She's a professor of law and of public international law. She's also the chairperson of the United Nations Human Rights Committee. So today she will be talking about climate change and human rights litigation. So I'll give a very brief introduction because I won't be able to do justice to her career. So she has published widely on succession of states to multilateral treaties. She's also a member of the ESO board, the European Society of International Law. And we're following a short lecture or a 30-minute lecture. We have a moderated session by our very own Professor Patricia Kalish, who's dialing in the middle of the night from New York. So, and I'll hand the floor over, or rather give the spotlight over to Professor Pazartzis to begin her lecture.
Well, before that, let me just say, Faye, how what a pleasure it is to have you again at the Academy. We really appreciate that you're doing this in the middle of the Human Rights Committee meeting that you're chairing. I'm also joining in from New York, as Violet said. And I have warm greetings also from Nilüfer, who's also here, but we decided to take turns so that not both of us would be awake in the middle of the night. But it's for you, it's a pleasure to do it and to welcome you and to moderate the session. The topic that you have chosen on human rights and climate change litigation could not be more appropriate this week as COP26 is meeting in Glasgow, and where we hear through the news every day, news about new cases coming up, connecting human rights and climate change. So we're eager to listen to your lecture. There'll be time for questions afterwards. So the floor is yours, Faye. I understand you have some slides to share. Go ahead.
Thank you very much, Patricia. And I thank, of course, the directors of the Center for International Law. It's good to be back. So I'm a recurring récidiviste, as we say in French. But I'm really happy to be back, and I'm happy that I have this opportunity to engage with you, even though I'm in Geneva. But I see that we have people from all over the world, I've been told, from New York to all the way out to Singapore and beyond, I understand. So I'm really very happy to be here with you again. And I thank you for this invitation. And when I was asked to do a lecture this year, and I was thinking about my topic, and actually, like Patricia says, right now, especially, we are getting there's a lot of discussion and a lot of things going on, I should say, in parallel, really. And this has been for the past few years. And now we're seeing developments happening also in the area of climate litigation, to which I will refer more extensively, perhaps this today. But through my presentation today, I just wanted to perhaps throw out to the audience a few questions that the audience might just want to think about, not only for this short lecture, but also generally as as climate change and the environment is entering really into our lives, and also I would say into the legal, hard law arena. So, I mean, and my questions would be, can we address issues of the environment, and in particular climate change, through justice, through judicial mechanisms, especially through human rights mechanisms, where justice is, and I would just, put it in quotes, individual, actually. And does current international law envisage environmental degradation as a human rights and accordingly a violation, which would incur state responsibility? The obstacles in litigating environmental issues on the basis of human rights obligations, and then, how this can help us look towards the future, think about the future. And I say this, as I said, in a context where we have seen a lot of movements both in diplomacy and adjudication. And when I say adjudication, I do want to stress the fact that, of course, here I will be referring perhaps to what is happening in international courts or mechanisms such as the Human Rights Committee, or more recently, the Committee on the Rights of Children. But in parallel, there have been, in parallel, first of all, there have been many cases within domestic jurisdictions. So there has been a jurisprudence which has been building up. See, for example, the Urgenda case here in the Netherlands and other cases, Klimaat now in Belgium. So those are cases that I won't be looking into, but it's just to give you the big framework, as you see here, that right now we're really right in between diplomacy and adjudication. And I would say that because, of course, we went through the Paris agreements in 2015, the SDGs that have been, there's been a movement on a diplomatic level moving towards addressing issues of climate change, as we all know, especially now the meeting this week, the upcoming weeks. And also within the Human Rights Council, which is the interstate, if you wish, organ for human rights here in Geneva, there have been a series of resolutions on human rights and climate change, building up to the very recent resolution, which was adopted just a few weeks ago, in the beginning of October, as you see here on my slide, recognizing the right to a safe, clean, and healthy and sustainable environment as a human right that is important, for the enjoyment of human rights. And also this resolution stresses the link between this right and other human rights. At the same time, on a diplomatic, I would say, level, the Human Rights Council decided on the same day to create again a special rapporteur and a special rapporteurship and a special rapporteur who will be dealing with the promotion and protection of human rights in the specific context of climate change. So, with this and then with Glasgow, so it's Geneva, Glasgow, there's a lot of work on a diplomatic level, how effective, how positive the results will be out of this diplomacy, we don't yet know. We can try to be, if you wish, optimist, but we'll wait and see. But the main issue and the important issue here is that climate change is now becoming part of, the everyday language. And part of, everyday concerns. And to this, of course, civil society, NGOs, individuals, and all other stakeholders, of course, have been very prominent and have worked dynamically to bring this issue to the fore. So, states are also grappling with this issue, as you know, but also there is a pressure from many sides. And of course, we saw the movement of children who are now becoming more directly involved in questions that have to do with their own future. So these are interesting developments, which also, I believe, Patricia will correct me, I think will also infuse and perhaps have an impact on international law itself as we move forward. So I think that this is one thing that I wanted to bring forward as I begin my lecture about the come and go between diplomacy and adjudication, to which I will be coming to. Now, as you know, before I just come to cases, I want to say that we don't find many instruments, legal instruments, which directly acknowledge or provide for our right as a human right, our right to a safe or healthy environment. As you know, this has been, I mean, there's some specific documents recognizing such a right, but in the realm of, for example, of what we do here and the Covenant, International Covenant on Civil and Political Rights, or other treaties referring to human rights, this issue is mostly closely linked to the right to life, or has been through the interpretation of the right to life, which exists in many human rights treaties, especially UN human rights treaties. On the other side, on a regional level, and I will just briefly refer to the European Convention on Human Rights, there as well, I mean, we have the right to life, which is Article 2, but also most of the case law of the European Court, which is, again, is very recent, has been hinging on the right to privacy and family life, which is Article 8. So, I mean, a direct right, you know, does not really, I mean, exist in I would say, in hard law, even though we do have many agreements, and of course there is soft law, and of course the law of the environment is not green anymore. You know, it's being strengthened by legal commitments as time goes by. So in this sense, as regards the Human Rights Committee, the committee had the opportunity to recently to flesh out its reading and its practice in particular in relation to the right to life, which is our Article 6, in its recent general comment number 36 in 2018. And at that point, you know, I mean, the change that has come in the last 2 or 3 years is absolutely, it's been, you know, quite rapid and perhaps even unpredictable. I mean, the extent of the rapidity of the changes had perhaps not been very clear, even at the moment when the Human Rights Committee, the 2 years that it was working on this general comment. But on the basis of the practice of the committee and the jurisprudence, there were very many, of course, interesting aspects. But the first aspect that the committee saw in interpreting the right to life is the fact that this right has some implications both on as to positive obligations as well as to negative obligations for individuals. And this is quite important, because for the committee, the duty to protect life implies that state parties should take appropriate measures to address the general conditions in society that may give rise to direct threats or prevent individuals from enjoying their right to life with dignity. So this was one interesting aspect which was fleshed out by the general comment. Again, I would say, you know, the general comments are just interpretative tools of the practice and jurisprudence of the committee, a sort of restatement of what our practice and our the practice of the committee and the jurisprudence has been. And another very interesting aspect, and I wanted to highlight it because it does come into, of course, the resolution recently adopted by the Human Rights Council, is that the idea of, you know, all these ideas of environmental degradation, climate change, development, etc., have to inform the right to life. So the content of the right to life. So the obligations of states parties to respect and ensure the right to life should also be informed, of course, of what is happening, you know, under general international law, environmental law, and so forth. And that is important because it links also perhaps to certain recent cases, some of which you might have, of course, already heard about, and perhaps that we might discuss. So these are some interesting aspects, I think, that are starting to be fleshed out, and perhaps even before the general comment in other fora, in particular, for example, the Inter-American Court of Human Rights, which has always been quite progressive and advanced in the way that it addresses human rights, as you probably all know. So, so I think that, you know, one of the basic, I mean, some of the basic directions we can already find in the jurisprudence of the Inter-American Court of Human Rights. In particular, of course, in the very famous advisory opinion of the Inter-American Court of Human Rights on human rights and the environment, which was adopted in 2017. So this was, you know, this was because this has been incremental, I have to say, across bodies, across the jurisdictions. We have had an incremental type of way of addressing these issues. So in the advisory opinion, the Inter-American Court recognized this existence of an undeniable relationship between the protection of the environment and the realization of other human rights. So, you know, this was a first link, saying that there is a link between protecting the environment and other human rights. And this also, you know, to the extent that we have human rights that are guaranteed, if you wish, by international treaties, such as, of course, the Inter-American Convention, then the need to perhaps link these rights, which are human rights, to the protection of the environment is something that, you know, should be done. And this was just an advisory opinion of the court, but it was, you know, one of these breakthroughs, which then, you know, led to probably raising awareness of the possibility of turning to international bodies to litigate environmental degradation or climate change more recently. So that was, you know, there's a passage, and I will come back to that. And then, of course, the European Court of Human Rights has also had some cases. One was already adjudicated in January 2019, the Cordelia and others versus Italy, where the court, again, the court based itself there on Article 8 of the European Convention, the respect for private and family life, and found that the Italian authorities had failed to protect the applicants. There were about 180 applicants in that case. In the areas, you know, which were affected by the toxic emissions from this factory in Taranto. So it was actually a finding of the court of a failure of the state to take positive measures, which then impacted on private and family life of the applicants. And of course, because as I was saying, you know, children are now at the forefront, if we can say, the youth is now at the forefront. There is currently a case of it's the Youth for Climate. It's widely known as the Youth for Climate case, which is again before the European Court. It's a group of children which have a claim against Portugal and 32 other states. So we will expect that with a lot of interest. So, you know, there has been a movement in litigation on an international sphere. And of course, this was also reflected in recent litigation or views that have been adopted by the Human Rights Committee since 2019 in particular, where there were two quite important cases, at least for this committee, in the sense that the committee looked into the relationship between the environment and the right to life. That was mostly the issue in the first case, which is Portillo Cáceres versus Paraguay, with the views of the committee adopted in 2019. And the second case, which really had to do actually with climate change per se and its potential impacts. And I will be coming and probably sharing just some thoughts, or at least some slides with about these two cases before I go to what is happening more recently. So, I mean, the first, if you wish, eruption, I would say, of issues of the environment directly to the committee with a strong link to the right to life, and of course to the right to privacy and family life, which is very important, I have to say, with regards to, especially to indigenous peoples, as was the issue in Portillo Cáceres, you know, and farmers who really live off an area, who, you know, this is basically the impact of environmental degradation on even on private life, because it impacts, you know, people or group of people who live off land and who, you know, cultivate land. So in this specific case with Cáceres, it was, it concerned the application of pesticides to soy farms, you know, in an area where there was a lot of farming, and this had resulted in the death of a person and then poisoning, of course, of other people. And so the claimants said that this impacted their living conditions, the water, the domestic economy, and by all of that, the state had violated its duty to protect, and of course, for due diligence. So this is the way this case came to the committee. So actually, the committee had to address and assess whether the state party had violated Article 6, which is, you know, the right to life, by this omission of its duty to protect, of the state, of its duty to protect life. And in an important holding, the committee held that this aerial spraying by the state with these toxic substances constituted a threat to the lives of the complainants. And this threat was something which was reasonably foreseen. And this idea of reasonably foreseen, I will come back to it again, by the state party. It could have been reasonably foreseen, and it was reasonably foreseen. There were actions. I mean, the committee knew that the state party was aware of the situation, and the committee considered that the state party had not put into place the adequate controls over illegal polluting activities, and therefore also violated the right to family life. And I was, you know, I was referring to this idea of, you know, small communities which really are impacted quite heavily, and we see this in Latin America, but elsewhere as well, are really impacted by climate change, and where states are slowly becoming aware of the fact that they do have certain duties, positive duties. And this is translating itself, you know, because sometimes on a diplomatic level, I mean, and here of course, I have to say that I'm speaking in my personal capacity in case I didn't mention it. But I mean, you know, in diplomacy, we see a lot of promises, a lot of calls to action. You know, we see this, but we need to see how this will be translated, you know, into specific action, and to then perhaps specific actionable claims. And this is something I don't know that I would like to discuss, and I think that we will probably, you know, see what will happen. And the second case, before I return to a much more recent one for the concerning children, really this Toyota case versus New Zealand, which again was quite discussed in in public dialogue and blogs, etc., and academia, had to do with directly with climate change, with what would be the impact of climate change to people themselves. Especially, this was a case of, it was actually a case of deportation. It wasn't a case of climate change. It turned to be, an issue of climate change because of what some of the things that the committee said, but it was not, directly an issue of climate change. But, of course, it added to the dialogue. And this gentleman was a national of Kiribati. So he moved to New Zealand. And when he moved there, he applied for asylum. And he was claiming that, to New Zealand, that if you send me back to Kiribati, then I would be subjected to a real risk of harm to my life. And these are the standards the committee has in viewing its cases of deportation. And he was asking not to be removed not to be sent back to Kiribati. So what the committee had to do in this case, and what was the issue here, because the claimant was saying, there is now this the rise of the sea level. And its effects are starting to be seen in small island states, as you know. And there are projections by bodies, by UN bodies and other bodies, that within a 10 or 15 years time frame, many of these islands will be submerged. Now, when the claimant brought this case, as I say, as a case of it was actually a case of deportation. So the committee had to look into its standards of whether the author would face a real and foreseeable risk to his life or to degrading treatment. And while this was acknowledged by the committee, that the right to life should also be interpreted as requiring positive measures. Here we get into, if you wish, the substance. But the committee was not able to determine that there was a real and foreseeable risk, and by that meaning something that would happen in the near future, to be able to determine a violation by the state party, by New Zealand, of this individual's rights. So and it will bring me to, the last case I want to look in with you before I just ask my questions and throw them out to you, with the children's case of the committee and the rights of the child. These cases actually have led to inadmissibility decisions. So, we need to be a little careful, I would say, and cautious in seeing how and if and how cases concerning climate change are to be litigated before international courts. Because, there are also issues of jurisdiction, of victim status, of the instruments that give either courts or organs, such as our court organ, the jurisprudence, the jurisdiction to look into cases. So there are very interesting issues that arise that are basically jurisdictional issues. And sometimes, while this can lead to a frustration by victims or claimants, these jurisdictional issues, and I'm sure Patricia is well aware, can be obstacles either to litigation by individuals or even to state litigation. So this is something I think we need to take into consideration. However, this case was important, and I think it will remain, one of the important cases of the Human Rights Committee, in the sense that this idea of positive obligations of states to respect and ensure the right to life has been once more reaffirmed. And in this context, in the context of the Human Rights Committee, in the context of the Covenant on Civil and Political Rights. And I will finally turn to, again, a very recent case, which again has been, I think there's been a lot of discussion going on about this case, even when it was first brought to the Committee on the Rights of the Child, which is one of our sister committees. It's not the Human Rights Committee, but it's one of the treaty bodies which deals with, is the monitoring body of the UN Convention on the Rights of Children, on children's rights. So this was, again, a very highly mediatized case of 16 children complainants who brought a complaint before the Committee on the Rights of the Child in Saki and others against five state parties, no less, complaining. And what were they complaining? That by recklessly causing, just a moment, causing and perpetuating life-threatening climate change, the respondent states had failed to take the necessary preventive and precautionary measures to respect, protect, and fulfill the claimant's right to life. Now, this was, as I said, a very important case, which I'm sure there will be a lot of discussion about. And I have to say that it was interesting in the fact that the committee did have a very extensive way to approach this issue. It was very careful, of course, in seeing whether, again, the issue was the right to life under, again, the covenant on the convention, excuse me, on the rights of the child. Okay, so let's just be clear about that. So, but it had to look into all these various issues, both of its jurisdiction, of course, and the issue of admitting such a claim. And I think the findings of the committee, even though it held finally that the case was inadmissible because the claimants hadn't exhausted all the available domestic remedies. So, but it did hold, it did have some important findings that I think we'll probably be looking at again in the future, that a state party to the Convention of the Rights of the Child can potentially be held responsible for the negative impact of carbon emissions on the rights of children, and this both within and outside its territory. So this issue of extraterritoriality of human rights, I think, and environmental rights, I think will be probably the issue of the future. So, ladies and gentlemen, I want to just come to perhaps just a few final thoughts on whether or not there is a future for what is now called in media and elsewhere, climate justice, what this is exactly. I want to say, first of all, that it is probably domestic courts that will take the lead in this, and they're already taking the lead. I was referring to the Urgenda case, but there are cases around the world, and also in the European context. I think the German Constitutional Court recently has adjudicated a very important case on Germany's obligations under its constitution to the protection of the environment. But so one of my remarks on this, climate justice, is that we will first probably be seeing more of these cases being brought before domestic courts. And I think, you know, the TCO's, the children's case that I was referring to right before, the Sashi case, you know, the committee was, and the committee was very also explicit in I think in dialogue again, because it held oral, also, you know, oral meetings with both parties. And it was careful in explaining to the children applicants that while it's very sensitive, and of course all bodies are sensitive to the views and to the claims brought by people, by individuals, including children. Each court will have to look at its own jurisdictional provisions in order to be able to adjudicate such cases on the merits. So I would say that having in mind that I think that domestic courts will be and should be also becoming much more visible and more proactive. I mean, in addressing cases concerning not only the environment, but, you know, specifically climate change, which is an aspect of the environment, you know, because we're going into, as you know, uncharted territory, in my opinion, in this sense. What we can take away, and what I just wanted to leave you with, perhaps, and if we have time, go into some of these issues, is that one thing we are seeing is that the environment has been linked now to human rights, to the protection of, you know, a right to life with dignity, and also to other human rights, including social and economic rights. And this will be, I think, the way that this is, I think, a takeaway that there are now positive obligations forming within international law on the protection of the environment through this linkage to specific human rights, which have been, you know, internationally recognized many, many years ago. And this, for me, will have possible implications on this responsibility of states for environmental damage. Up to now, as you know, there's been a lot of talk, and of course, the International Law Commission, when working on environmental damage or harm to the environment, really has dealt with issues of liability, meaning actions that perhaps might not violate specific obligations of international law, but nonetheless create you know, liabilities issues for states. So this was, you know, a path that environmental law was treading on, but now I think we're going to see changes also in the way that international responsibility is incurred for states, you know, for acts or omissions, for damages to the environment. Now, let me just say that, of course, this will be, you know, this will be a very important development, which we will be seeing. We're already seeing, and I think these cases that I just showed you, and of course, they're just some of them. There's more coming in the pipeline, and some more to be adjudicated. So we will have to see what international courts will say as well. Into some issues. I mean, I'm referring to obstacles, but I think that we have already. Let me look at it into a more positive, if you wish, way to address it. That this, you know, the nature of international adjudication, what I call the consensual nature, as you know, international bodies cannot adjudicate, and states have accepted this possibility. This has been accepted by states, for example, when they accept to be part of optional protocols, allowing individual complaints, as is the case in the Human Rights Committee and other treaty bodies, and also, of course, within the regional systems, which allow for individuals to bring cases forward, such as the Inter-American Court of Human Rights and the European Court of Human Rights. But, that will not be enough, and that's what we've seen with this. There will be the issue of standing and victimhood. This has been discussed in recent cases, especially, how to determine whether a specific individual has been, a victim of a violation by a state through the act or omission of a state, how you can attribute, how you can have causality, how you can attribute, how you can actually determine. Courts will need to determine the link, the causal link between states which go act or omit to act. And this is with the carbon emissions, for example, or with a failure to adopt policies, and how this can be linked with the specific climate change impacts which can adversely affect internationally protected human rights. So these are special legal issues which still need to be fleshed out. I have to say that the Inter-American Court again has been much more forward than other courts or mechanism, especially with the issue which I will come to here about applying human rights standards extraterritorially. So this issue of extraterritoriality is quite important because it was a stake with the children. I mean, these children lived in various states and were actually suing, if I can say, were making claims against states to which they really had no specific links. So it was an issue of the extraterritorial effects of climate change to actions which occur outside the state where the effects are acutely felt. So this is an issue which will have to be fleshed out, because courts, as you know, take according to what is provided through their instruments, have taken various positions toward the issue of extraterritoriality. And finally, I have to say that linking to this, of course, will be attribution. So really, these are questions that are coming squarely within state responsibility. I mean, we're moving from liability to state responsibility per se. And I will end my remarks with one final remark, which, of course, because some of these cases have not come to, an end or a result, but we will need to see what will happen in terms of repairing and how you can repair through adjudication damages caused to the environment. Can this be monetized? Can lives be monetized in terms of compensation, a monetary compensation, or will we need to really looking into remedies that are future oriented, since also these issues are future oriented. These are some thoughts I wanted to share with you. I don't know if we have time for perhaps some questions, but I just wanted to share these thoughts and perhaps end with something that Marty Koskenemi has, a response he has given, because he mostly asks questions. So in one of his works, which is entitled "What is International Law For?", where generally he deconstructs, as is usual for Marty Koskenemi, but he does see also maybe a hope for international law as the promise of justice. So with these few thoughts, I hope I haven't bombarded you, but I would like to end again and thank everyone for listening to me, and thank the organizers for inviting me again to share these thoughts today with you. So thank you very much. Patricia, over to you.
Thank you so much, Professor Pazartzis, DFA, for this excellent presentation on recent developments. This is something that we have to monitor, but it's clear. I mean, it's clear that there's a link between human rights and climate change. That's very clear. That it's clear that also this link has been made even more evident by the resort to human rights treaty bodies that you have illustrated, like the Human Rights Committee and the Committee on the Rights of the Child. I know there's lots of cases also in the pipeline, and also in other jurisdictions like the European Court or the Inter-American, and the domestic jurisdictions that you've also mentioned. So this is clearly a field that is booming. I wonder also if the creation or the recognition of the right to a healthy environment is going also to add to this mix. But I'm not going to ask any question. I know we have here a question in the chat that I will read for you. We have limited time, and normally we go over the hour, but now today we have to finish before the hour. Because Professor Pazartzis is going to be, chairing the Human Rights Committee meeting at 10 o'clock Geneva time. So we have to finish just a little bit before the time. And also you have double lectures today because Professor Sayapin will continue. But so we will take this first question from Shamsul from Bangladesh about the question is, I'd like to know about the implementation of the judgment in Cordelia and others versus Italy, the case that you mentioned. I don't know if you can add some detail about the implementation of the judgment.
Well, Shamsul, thank you for your question. This is a very recent case, so it's within the implementation procedures of the European Court of Human Rights and the Council of Europe. As you know, they have their own procedures to monitor the implementation of states. So I don't have any specifics to share with you at this point. I haven't recently looked into what is happening with the implementation. However, the finding, the decision and the judgment of the court, I think, did make it clear that Italy had to take certain measures to domestically to ensure that the applicants' rights were effectively protected from these emissions, and that would include legislative and other measures. So, I mean, those then come into the implementation procedure according to, Article 45 of the European Convention of Human Rights. So I'm not sure, but we are also monitoring to see, how then domestic, because it goes back, as you know, to domestic authorities. And then domestic authorities have to come up with a way of addressing these issues. That is a big question, Shamsul. What if Italy fails? What if any state fails to abide by judgments or decisions of international courts? That is the big question for international law that probably the International Law Commission will solve, and not myself.
Don't get your hopes too high.
I mean, what is happening, with most bodies have a follow-up on the implementation by states of their, not only of their recommendations, such as we have, but also of the judgments of the courts. These are procedures that are happening both within the European Court and its connection to the Council of Europe, but the European Court is now looking itself into judgments. So it can come back, for example, potentially, if a state fails, and it can come back and ask for specific measures by the state party, or it can come back, for example, and award specifically measures even of compensation itself if the domestic authorities do not award these measures of satisfaction, as they are called, within the European rights system themselves. Okay, so this will be an issue of going back and forth between the state and the court, and of course, through these follow-up mechanisms, now the European Court itself has the possibility really to come back to states and see how they are implementing the court's judgments. The Inter-American Court of Human Rights has wider powers in this regard. So usually, it goes forth with also addressing the remedies themselves that the state has to take. And usually it's a very wide spectrum of remedies. And this is one of the particularities of the Inter-American Court of Human Rights. Will it discourage? It won't discourage. No, it will not discourage the growth of climate justice, in my opinion, Shamsul. And that I think basically because now, public opinion has been made so aware of these issues that I don't think, and seeing the cases and as they build up, and as Patricia implied, I mean, there are cases in the pipelines of many bodies, not only of the Human Rights Committee, but before the European Court and other courts. I think that climate justice is here to stay, if I may say so. It might be frustrating in the beginning for reasons which I explained, but I don't think that we will be turning back. It might be a slow progress, especially on the field of judicial settlement. Let me put it that way. We are not waiting to see what diplomacy will do, because as you know, states have the final say, and we need to see what states will be actually willing to do, and in black and white letters, Shamsul, before seeing what climate justice can bring about. But I think we're already there with climate justice. So thank you very much for these questions addressed to courts. Thank you.
Thank you, Faye. I saw that your alarm went off. It's a good reminder. There's one more question. Can we see if that question is quick? And then that will be the last one. It's a live question from Jill Anthony from the Philippines. Sure. Make it quick, Jill.
Yes, look, I have a lot of questions, but I'll just limit it to one. Just your thoughts on exhaustion of local remedies, because I'm a bit worried about it, because it's a requirement for all human rights tribunals, right? The exhaustion of local remedies. But the Sachi case is really about their international obligations, like cooperation and transboundary harm. So I think there may be a disconnect later on. It's not really a question, but just your thoughts on it. Is it good, or is it good to adhere to that, or do you think the tribunal should adopt a more lenient approach because of the nature of the obligations?
I'm afraid I have to say that this is one of the jurisdictional prerequisites, and as you know, it's a prerequisite that we find in many international courts dealing with individual complaints. International human rights courts and mechanisms, and you can imagine that without this sort of first barrier, which first of all brings the burden of the responsibility to the state and to the domestic authorities on the first, in the first part. And second of all, also tries to limit the flood, the potential flooding of international courts by cases and the impossibility to handle them. So in this sense, if you wish, I think that it will be hard to interpret this jurisdictional hurdle in a way which would be, favorable to such complaints. I mean, this remains to be seen, but, even in the children's case, domestic remedies weren't exhausted. And I think, the children were quite upset about this jurisdictional hurdle, but it's something that, we need to keep in mind going forward, and perhaps that's why I consider that, the domestic courts will have to, live up also to these issues and come forth when claimants are reaching to them first, to address these issues. That's as far as I can respond to your concern or frustration for the future. Yeah.
Yeah, thank you so much, Faye. I mean, this is clearly an important point. It's a basic tenet of international adjudication, the exhaustion of local remedies. We'll see what developments come in our way. So I have to liberate you as promised. We are so grateful that you took the time to be with us today from Geneva and gave us another excellent lecture. I knew if we had the time, there would be a few more questions for sure. So we'll have to make you come back at the next edition.
Thank you, Patricia.
And all the
very
best.
Kind.
All the best for your meeting, and please accept on behalf of Nilofer, of myself, of the center, and all the participants our greatest and very warm thanks for again being with us and for your excellent lecture. And we'll give you some virtual clapping still at the virtual level, and all the best, Faye, and see you soon. And
thank
thanks
you
again.
very much. And I'm willing even to receive questions through my university email. Students will know how to reach me if they want. But thank you for giving me this opportunity again to engage with your vibrant community in Singapore. Thanks to all of you.
Thank you so much. See you soon. Bye-bye.